We got a question a while back from a client. They'd gotten a diagnosis of dementia for dad, and the immediate question was, do I need a guardianship?
That is absolutely one of my favorite questions and the answer is no. Okay. Just because a person has a diagnosis of dementia does not mean that they need a guardianship.
I've heard you actually say that we give up, as elder law attorneys, many of us give up on our clients, the people we're trying to help, too early in the dementia process.
We as attorneys are to fight for the freedoms of our clients' rights. Mm-hmm. And I think attorneys give up way too quick when they go get a guardianship on someone who can't fully answer every question that is asked them, or they forget what they had for breakfast. Does that mean we need to take away all of their rights and give it to someone else? No.
Here's a for instance. If my mom has dementia, and sometimes it's 1958 and she's in Western New York State, mm-hmm. but other times she knows exactly who I am, would understand the significance of her actions, would understand, for instance, that she's giving up control of her house or mm-hmm. something of that nature. You're of the opinion, and I share it with you, unless I'm wrong, you're of the opinion that she's okay to sign that document at that point in time.
Yes. Just because, she may think it's 1950, whatever. Who is this person with you? Oh, that's my son. Do you trust him to manage your affairs? Yeah. He's been doing it for months anyway. Let's sign this document that legally authorizes him to do that. That way we don't have to file a guardianship. And please understand, a guardianship is taking the rights away from a person. It is a legal process, just like a criminal action. Someone is convicted of a crime and the jury says, yes, you are guilty. They go to prison. We are taking away their rights. That's very similar to what a guardianship is. We're taking the person's rights away. And we as attorneys are to fight for the rights of our people. And another reason I fight for that so much is because typically to do the Medicaid planning, which we have talked about before, particularly for a married person, we have to do things with your assets, transfer it from one spouse to the other, and in almost all states, you cannot do that under a guardianship without the approval of a judge. And sometimes judges may say, I just don't think we're going to do that.
Or let's bring that ad litem attorney back in here and take another look at it, or whatever the case
might be. It's time, it's money, it's just a mess. But the bottom line is, just because someone has dementia doesn't mean that you have to do a guardianship. It does take more work for the attorney to get through some of those questions, and typically we charge less for those documents that we're signing than doing a guardianship.
Right.
Which brings up.
And you raise a great point there. We're talking about guardianship, and what we're really doing is underscoring the absolute necessity that everybody have the right powers of attorney outstanding before they need them.
Do it early so there is no question.